Yeah, I did. Thank you. Thank you. No, 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 no. I was just surprised.
Yeah, I'm waiting on him.
Hey, good morning. How you doing? Good morning, Mr. Marshall.
More Judge.
You here for Mr. Wise?
I have Mr. Wise, yes.
Case number 2305-89950, people of the state of Michigan versus Gary Y. Defendant is charged in count one, assault with intent to do great bodily harm, less than murder by strangulation. Count two, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Hugh Marshall, P48269, on behalf of Eric Wise, who I see on the screen. We consent to Zoom for today's hearing.
Mr. Wise, tell me your name for the record.
Eric Wise.
What's your pleasure, Mr. Marshall?
Your Honor, I just received discovery last night. I forwarded it to Mr. Wise this morning. I wonder if we could have another PCC so he can look over the discovery and then make a decision. I see you shaking your head. So that's not an option.
Is there only if there's a possibility that you yourself short of an exam? Otherwise, we need to go ahead and set the exam date.
Well, this is just to determine whether or not he wishes to waive or not, but whatever the court desires.
Okay, I can give you another PCC for Friday, October 6th. I'm sorry, not October 6th. Scratch that. Friday, September 29th. If he determines that he wants an exam, then the exam will be October 4th.
Okay, we can do that. We can come on the 29th.
Okay. I'll adjourn the probable cause conference to September 29th at 8:30. Final be continued.
Thank you, Your Honor.
Ms. Drain,
Yes, Judge.
are you trying to come in again?
Yes, because I wanted to log in on my laptop instead of my phone. That's all.
Okay, just no funny stuff going on, that's all.
Thank you.
Okay. Good morning, Mr. Gagnon.
Good morning, sir. I'm with Isaiah Maya today. It's a PCC.
Okay. Yeah, regular Maya.
He may or may not be in your weight room. I am in communication.
Okay, I don't see him, I just have an iPhone there, I don't know who that is, though.
May I waive his presence to set an exam date?
Sure, let me call him.
Calling in case number 2305-89-9201. Before the state of Michigan versus Isaiah Meyer. Defendant is charged in count one, assault with intent to do great bodily harm, less than murder by strangulation. Count two, malicious destruction of personal property, 200 or more but less than 1,000. Count three, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Brian Gagnick, sir, Neighborhood Defender Service, P64220. May I waive my client's presence for this hearing?
You may. What's your question?
I'd ask for a preliminary examination date, please.
How's October 4th at 9 o'clock?
Your Honor, can we go just a little bit later in the morning? I have to be across the street at 8:30, and I know it's going to go at 8:30.
October 4th at 11 o'clock?
Accepted. Thank you.
October 4th at 11 o'clock, bond will be continued.
Thanks again.
Mr. Williams. Unmute yourself.
Yes, sir.
We're just waiting on your attorney, sir. Have you talked to him?
No, I haven't talked to nobody, sir.
All right. She should be here soon. Mr. Johnson, Brooklyn.
Yes.
We're waiting on your attorney as well, sir. Have you talked to your attorney?
No, sir.
Okay. Hopefully they'll be here soon as well.
Okay.
Mr. Williams,
Yes, sir.
are you trying to come in my waiting room again?
No.
No? Okay, thank you.
Well,
Funny business, goodbye. So around the crowd this morning.
Yes, sir.
That's your type of going on?
No, sir.
Hey, what's up, man? Yes, sir. How's your time? Do you have an attorney for Johnson? Ms. Drain,
Yes, Judge.
do you have Marad, or is that a special assigned case?
That is a specially assigned case. I'll find out who it is.
All right, thank you.
Okay, thanks.
Are y'all laughing because y'all agree?
I'm sorry.
I'm just wondering, are we laughing because we agree or we disagree? They have to agree. I'm telling you.
Judge, I'm just gonna stand in for that Rod Williams case whenever the court is ready.
Okay, we're just waiting on the attorney to get here.
Thank you.
Good morning.
Good morning. You are here on Murad Williams.
Yes, Judge, thank you.
Okay, we're ready.
Case number 2105-643401 for the state of Michigan versus Murad Williams. Defendant charged in count 1 criminal sexual conduct, 4 degree. Count 2 criminal sexual conduct.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drink for the people, P number 605. 295, sorry.
Good morning, Your Honor. Thomas C. Jeffers on behalf of Ms. Murad Williams, P42872.
Tell us your name for the record.
Rod Williams.
What's your pleasure, Ms. Jefferson?
Your Honor, this time we ask this be set for a live exam.
The court will continue to plead not guilty and set this matter for preliminary examination. How is October 4th at 9 o'clock?
Not a good day. Can we do the 5th, Judge?
How about October 2nd at 12 o'clock?
That works.
October 2nd at 12 o'clock, final we continue.
Thank you. Can I get a breakout room, Mr. Murad, Mr. Williams?
How do I go in the break room?
I'm gonna talk to you. Oh, they're gonna,
Meeting room, sir.
okay,
Right.
hit join.
Ms. Baird, I appreciate your time. Good morning.
Good morning, Your Honor. Thank you. I appreciate the support's efficiency.
Ready on Brewster?
Yes, I am.
Okay. Morning, Judge. Good morning, sir.
Case number 2305-878901 for the state of Michigan versus Allen Brewster. Defendant charged in count 1, assault with intent to commit violent crime, less than murder or less strangulation. Count 2, interfere with crime report. Count 3, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Gabrielle also requesting permission to practice under the court rule 8.120 under the supervision of APA shall be preparing over Zoom.
Here.
Good morning, Your Honor. May it please the court, left here, 58142, hearing on behalf of Alan Worcester. State your
Commission granted. What's your pleasure? Oh, today's the day time set for preliminary examination. Are we ready to proceed?
No, Your Honor, the plaintiff witness in this case is Ms. Samantha Miller. She's not present. People are unable to proceed with other testimony.
Your Honor, we're requesting a dismissal of this.
So ordered. Court will dismiss this matter without prejudice. I need a dismissal order.
Thank you.
We have an attorney here, Johnson.
Oh, we didn't do it. Oh, okay. Ready to call it?
Case number 5898901, state Michigan versus Roy Johnson Brooks. Defendant is charged in count 1, home invasion person. Count 2, weapons, firearm, possession by felon. Count 3 and 4, assault with a dangerous weapon. Counts 5, 6, and 7, weapons, felony, firearm. Count 8, domestic violence. Defendant has a habitual offender second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Joseph Felix, D 42284. I received a call from attorney assignment about 10 minutes ago, and they assigned me this case. I don't know why the late assignment there. I have no explanation why I received the call this morning and no paperwork. But nevertheless, I accepted the case for the home.
Well, we just noticed this morning that he wasn't assigned an attorney, so we made a call to the assignment clerk. And they called you.
That explains everything, Judge.
All right, so that being said, how would you like to proceed?
Yeah, I'd like to kind of a lengthy adjournment because citing all the charges, as long as I can get, so I can get the discovery and go meet him. I don't know if he's incarcerated or not.
Ms. Strain, when can you get that discovery to counsel?
I can get that to him today.
Okay, so we can get it to you today.
Yes.
I'll adjourn the probable cause conference to September 29th, this Friday. And most likely, if you choose to have an exam, we'll probably have it October 4th.
October 4th.
Yes, sir.
Judge, I'm sorry, I can't do with that. I can't work that schedule. I don't want to inconvenience the court anyway, but I'll call it for any assignment time. I can't deal with it.
What's wrong with October 4th?
October 4th, I can do October 4th. October 4th is that's the day I just cannot do. I can't do October 4th. I have an Allen Park in-person exam, and I also have something else on another 4th. I can't do the 4th.
No time, anything?
No, Judge. I have a trial in the afternoon. That's the worst day of the month. It's just the worst day of the month. The 6th I could do. The 6th I could do, but the 4th is not a possibility. Whatever you'd like for me to do, I'll do.
There may even be a possibility that it rained with the or not.
You know, Judge, I'm in good standing with Your Honor. I don't want to have that go downhill. Let's just get another attorney to handle it. I don't want to put you at any inconvenience. You know, I have to consider the defendant also all these charges. Let me just get somebody else to deal with it. Okay. I'll make the call right outside the door. Come back. All right. Thank you, sir.
Mr. Notes, good morning. Right, the notes, aren't you? Oh, that's Bill.
Yes, sir.
Hey, how you doing, Mr. Proctor?
I'm good,
You
too.
look just like, Mr. Notes. Sorry, I didn't get a chance to turn it.
I understand where it's used.
Yes, they are. Yes, they teach. Oh, I see. Oh. So. I was supposed to see if I could do. Yeah, we have to finish it. Okay. Yes, sir. See you then. Thank you.
Judge King,
Yes, sir.
the attorney assignment is gonna find someone and appoint them to represent this.
Okay.
Thank you.
Morning, Mr. King.
Good morning, Jeff.
Are we ready on deal?
Just about.
Hey, there you go. How you doing, Mr. Cooper?
I'm doing well, Judge. How about you?
Good, I just had to make sure it was you. We got a lot of perverts trying to infiltrate again today.
Uh-oh.
Okay, so this is our spot appointment for Brookings, Johnson Brookings.
I'm just going to run and get my calendar, Judge.
She's not.
Okay, already.
And we're waiting on this drain to come in.
I'm going back into a breakout room now.
Thank you. Good morning.
Good morning, thank you, sir.
Can we get this drain on this crew?
Calling case number 230589890 before the state of Michigan versus Ward Johnson Wilkins. Defendant is charged in count one home invasion, first degree, count two weapons, firearm possession by felon, counts 3 and 4 assault with a dangerous weapon, counts 5, 6, and 7 weapons, felony firearm, count 8 domestic violence. Defendant has a habitual offender second offense notice.
Appearances for the record, please.
Good morning, Your Honor, Gabrielle Pruitt, requesting permission of practice under Court Rule 8.120, standing in for the attorney.
Mr. Grant. Mr. Grant.
APA Shelby Grant.
Good morning, Judge. Robert Kenneth, here on behalf of Mr. Gill, who's fasting on that.
We can go ahead.
Johnson.
Johnson. Mr. Cooper's case. He's on Zoom. Mr. Cooper, your appearance?
Renee Cooper, I don't know if I've been formally assigned to Roy Johnson Brookins.
I thought you said the assignment clerk called you.
Oh, they did. And so I didn't know if I had been recognized by you yet.
Yes, you have. Okay. What's your pleasure, Mr. Cooper?
Well, not having any discovery and not having a way to contact Mr. Brookins or Johnson Brookins, I'd like a new PCC, please.
Okay, so Mr. Johnson Brookins is here. And now that we know who the attorney will be, I'm sure we can get that discovery to you by today. But just the same, I'll adjourn the PCC to Friday, September 29th at 8:30. Give you an opportunity to decide what you're going to do. And if in fact you do decide to hold the exam, I'm looking at an exam date of October 4th.
Okay, well, you know, I have a trial starting that morning before Judge Bridget Hathaway. Now, it is a bench trial, and so I probably can ask her to allow me to go to your courtroom first. If that is a definite date, Judge.
I can set it for 1:30.
Oh, no, that would be worse. I mean, it's going to at least be a 2-day bench trial. Well, no, it's a 1-day bench trial, but it might go into the second day.
People hold 2-day bench trials.
Well, you know, it's a difficult client, Judge. Let's just put it like that.
Well, I can do you as early as 9 o'clock.
Okay. I'll tell Judge Hathaway to, you know, wait until 10 o'clock to expect me.
Okay. And in the meantime, I can put you in the breakout room with Mr. Johnson Brookins so you guys can introduce yourselves.
I appreciate that.
Hey, Brad. Yeah. You go ahead and get signed yet?
Go ahead and join the breakout room.
All right.
So we'll adjourn the probable cause conference into September 29th at 8:30. We'll set an exam date for October 4th at 9 o'clock. We continue. Okay, Mr. King, who's been waiting patiently. Calling case 2358816, people of the state of Michigan versus Buddy Roy Gill. Defendant is charged with count 1 assault with a dangerous weapon, count 2 felony firearm, count 3 domestic violence. Appearances for the record, please.
Good morning, Your Honor, Gabrielle Pruitt, requesting permission of practice under Court Rule 8.120 under the supervision of APA Shelby Grant.
Commissioner Grant.
Good morning, Judge. Robert Kenneth, here on behalf of Mr. Gill, who's fasting.
Today's the date, time set for preliminary examination. Your name for the record, sir.
Morning, Gill.
Are we ready to proceed?
The people are ready, Your Honor.
How many witnesses will be?
1.
Ready to call you?
I am ready to call my witness, but I don't know if that's something they want to do.
Yeah, he's executed the way.
Oh, did he? Okay. Mr. Gill, please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Sure. Thank you, sir. You understand you have a statutory right to have a preliminary examination by waiving the same that means you won't have one. And you'll be bound over to Wayne County Third Circuit Court as you stand charged. You understand that?
Yes, sir.
You understand the nature and the purpose of the preliminary examination?
Yes.
You understand, if you were to have one, the prosecution would have to establish a crime and charge the city of Detroit with probable cause for you committed it.
Yes.
Is anyone forcing you to waive your right?
No.
Has anyone promised you?
No.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No, Your Honor.
The court finds the defendant's waiver is made knowingly and voluntarily free. The court finds the defendant over to any time of the circuit court. Criminal division for proceedings is arraignment only information date and time will be October 11th, 2023 at 9:00 a.m. Bond.
Thank you, Judge.
Thank you, Your Honor.
Have a good day.
Have a good day.
Thank you.
We're good, Judge. Thank you.
Okay, you're all set? All right,
All
thank
right.
you.
Thank
Good
you.
day.
You too.
Good morning, Mr. O. How you doing?
Good. Have you met Corey Yanks? I'm the new attorney at our office.
I'm your attorney in their office. What's your name again?
Where you at?
Nice to meet you. Approach for a second. This way.
Okay, thank you.
Sir, are those prescription glasses? Yes, sir. Nice. Wayne Hawkins. Yes, sir. Calling case 2358879, people of the state of Michigan versus Dwayne D'Angelo Hawkins. Defendant is charged in count 1 assault with intent to break violent harm, domestic murder by strangulation. Count 2 domestic violence, third offense notice. Appearances for the record.
Good morning, Your Honor. Gabrielle Cooler requesting permission to practice under Court Rule 8.120 under the supervision of APA Kelly Green.
Good morning, Judge. No objection, Judge.
Permission granted.
One with NDSP 83424, hearing now against Mr. Hawkins, who's present in the courtroom. Mr. Hawkins, please state your name.
Dwayne Hawkins. Today's daytime separate preliminary examination. Are we ready to proceed?
No, Your Honor, the complaining witness is not present. The people would ask for 5 more minutes. Thank you.
PSC report done for Jesse Harris. Jesse Harris, 10 o'clock.
I don't see. Looks like we do have it.
If we're ready on the Hawkins case.
Okay. Recalling 2358879, people versus Wayne D'Angelo Hawkins. Are people ready to proceed?
No, Your Honor, the complaining witness is now present, and the people are unable to proceed without testimony.
There's the council moves to dismiss without prejudice.
So we're going to dismiss this matter without prejudice.
Thank you.
Mayor Pro Tem.
Yes, sir.
Okay.
Is Ms. Pilkowitz here?
She called and said she would be a little late.
You have witnesses on tape.
We do not have.
Morning, Ms. Woodside.
Good morning.
Where's Mr. Smith? We have Mr. Tate step in.
Tate is in custody.
He's in custody. Okay. I'm gonna call him his without his attorney.
She's like, we can call her. She'll try to Zoom it.
She can register herself.
I'm calling from Judge Kingsborough. We're looking for Maurice Taylor and Jesse Harris. Yes, we want Taylor right away. Yes, ma'am. Okay, thank you. Judge, the bus just got here.
Oh, did it? Okay.
She gonna set Tate up ASAP.
All right, thank you.
Well,
Do we have any other agendas of those two?
no, we got both.
That Tate and
Tate,
Taylor.
Harris, Austin.
Also, yeah.
Hi.
Go there.
Hi, I don't have any witnesses unfortunately, so
You don't anticipate them being here?
I made contact with the mom upon
after our PCC, and she was subpoenaed. They're not here. I texted her 3 times with no response.
Okay. The bus just got here, so wait.
Okay.
Ms. Woodside,
Yes, Your Honor.
who is your client?
Mr. Smith. Who I'm not sure why he's not here. Yes. And I stupidly left my phone in the car.
I'll give them some grace time. Mr. O, go ahead. Did you want to waive your client's appearance? We know that they're en route. They are in custody.
Sure, if the court has no objections to that.
I don't have a problem. Calling case 2358850, People of the State of Michigan versus Jesse Harris. Defendant is charged with count 1, criminal sexual conduct, second degree, person under 13, defendant 17 years of age or older. Count 2, indecent exposure. Defendant has an habitual offender, fourth offense known as mandatory 25-year sentence. Appearances for the record, please.
Good morning, Your Honor. Erin Wilmot, P82085, appearing on behalf of the people.
Good morning, Judge. Glenda with NJSP 83424, appearing on behalf of Mr. Harris, who is not present, asking the court to waive his presence at today's hearing.
Court will waive the defendant's presence. Today is the date and time set for preliminary examination. My understanding is that the people are not ready to proceed. Is that right?
The people are unable to proceed at this time. Just for the record, I did make contact with the mother of the complaining witness following the probable cause conference, informing her of the date, today's date, of the exam, and that she would need to bring the complaining witness. The mom also received a subpoena with that information. When I got to court today, I noticed that the mother, nor the complainant were here. I did call the mother. There was no answer. I sent 3 text messages, have not received a response, and they are still not here. So we are unable to proceed.
Judge, defense versus dismissal without prejudice.
So order for court will dismiss this matter without prejudice.
Thank you, Your Honor. No, thank you. Have a good day. Yeah. Go ahead.
Judge, may I approach?
Yes, sir.
Sorry, I'm late, Judge.
All right, Mr. Woods, we're still waiting on him to bring the inmates up. Do you want to understand that people aren't ready to proceed
Judge, when you say up, do you mean they're in the building or they're still?
in the building?
Then let's give it a minute or two. Yeah. Or he can stay down and lock up and I can see him after. If we want to do that. But if he's actively en route.
looks like he's coming in now.
What's your name, date, please?
Calling case 2358903, State of Michigan versus Maurice Sean Tate Jr. Been discharged in count 1 assault with intent to grave bodily harm, less than murder or by strangulation. Count 2 domestic violence. Appearances for the record.
Good morning, Your Honor. Gabrielle Court requesting permission of practice under Court Rule 8.120 under the supervision of APA Shelby Grant.
Commissioner Grant.
Good morning, Judge, Neighborhood Defender Service by Jack and Colby with PA 1653 on behalf of Maurice Tate, who stands to my left. Mr. Tate, will you state your name, Judge, please?
Maurice Tate.
There's a date time set for preliminary examination. Are we ready to proceed?
The people are unable to proceed at this moment, Your Honor.
Your Honor, I would move for dismissal without prejudice.
So order the court to dismiss this matter without prejudice.
Thank you. The court like me to prepare the order, Judge?
Yes.
Yes.
I'll call the conviction. I call him. I tell him.
Judge, this is Alana Aller, she's a new attorney at our office. She's shadowing me for today. We do. We brought in 5 law grads.
Congratulations. Good morning. What's your name
Thank you.
again?
My name is Alana Aller,
What law school?
Michigan.
Okay. Nice to meet you.
Nice to meet you too, Your
Go green, go white.
Honor. Understood.
Go brown, go gold.
Hey, how you doing?
Oh, yeah. Okay, good, that's good enough.
Okay.
Watch you do the same thing as Clifford.
Clifford Smith, calling case 2358546, Equal State of Michigan versus Clifford Smith. Defendant is charged in count 1 assault with a dangerous weapon, count 2 domestic violence. Defendant has been within the 30 minutes.
Good morning, Your Honor. Gabrielle Court requesting permission of practice under Court Rule 8.120 under the supervision of APA Shelby Grant.
Commissioner Grant.
Good morning, Your Honor. You and your staff. Please now report Sheriff Truckwood's on behalf of Mr. Clifford Smith. Our number is 41295. I don't believe Mr. Smith is not present. He's texted yesterday, but be here. So, and unfortunately, I left my phone at the car, but I'll see if I can try to reach it.
Okay, so that is an issue. This matter was scheduled for 10 o'clock. It's now 10:18. The defendant has failed to appear. The court will issue a K district vote bond and set the new bond at $25,000 cash.
I located the bring back forthwith.
All right. Have a good day.
Okay.
Yeah, there you go. I can take care of it.
Good day, Judge.
Thank you, you as well. Be safe out there.
Will do, sir.
Heather is going off.
Mr. Smith.
Huh?
That's Clifford Smith, the one that you brought.
He's here? Is Ms. Woodside gone?
No, yes.
What time are you supposed to be here, sir? First, take off the sunglasses. What time are you supposed to be here? What time is it? Excuse me?
I said, I know it's after 10.
Well after 10. Did you have witnesses on that? Come on in. I'm calling her now, but she doesn't have her phone. She's on her way to her car.
I know, got it.
Recalling case 2358546, people of the state of Michigan versus Clifford Smith. Defendant is charged in count one assault with a dangerous weapon, count two domestic violence. Defendant has a additional offense with third offense. Appearances for the record.
Good morning, Your Honor. Gabrielle Pro requesting permission to practice under Court Rule 8.120 under the supervision of APA Judge Grant.
Permission granted. Tell me your name, sir. So, Mr. Smith, you're supposed to be here at 10 o'clock, and you show up about 10:20. Why is that?
Driving.
You weren't driving. How'd you get here? She made you late?
No shit.
So why are you late? Just don't care.
No, I definitely care.
Because you know, I said the case is out for your arrest or your failure to appear. So I can actually put you in jail right now, and your bond will be $25,000 cash. Why shouldn't? I can't hear you.
So I apologize for being late, on. That's what we really like. Thank you. Move a little slow.
You moving a little slow. Why is that? How old are you?
40.
40 years old. You have back problems?
I put my back on.
You have back problems. Probably stress.
Tile, basement flooded. Kind of spraining my back.
All right. Are the people ready to proceed in this matter?
Your Honor, the complaining witness is not present and the people are unable to proceed with our testimony.
So I could adjourn this so that your attorney can come back. I want to be a real person. Or I can allow you to represent yourself that you asked for dismissal right now. Thank you. You haven't had any contact with Ms. Crane, have you?
No, sir.
You have a motion?
Yes, sir. Dismissal.
Motion to dismiss. This is your attorney calling right now. That's what's that. Yes, you showed up. Okay. Your attorney's gonna call and try to keep you out of jail. Thank you. She's coming on Zoom now. Hello there, Ms. Woodside.
Yep. Very good morning again, Your Honor.
So I've already called the case. Let me have your appearance for the record.
Please, the Honorable Court, Sharon Clark Woodside, appearing on behalf of Mr. Clifford Smith, who is now present in the courtroom.
So as you are aware, Mr. Smith came this earlier this morning while you were here. And we were just discussing why I shouldn't put him in jail right now.
Yeah, wow. I'm sorry.
Go ahead.
Wow. Look, I didn't realize the court was calling me on my other phone, and I was actually calling Mr. Smith when I realized that the court was calling me. So I'm sure Mr. Smith has a good explanation for why he was tardy this morning. I'd ask the court to recall the bench warrant.
So he really didn't give me a good excuse. He just said that he didn't drive. His girlfriend brought him here and he's just late. But he's very apologetic.
So if he's apologetic, Your Honor, I am as well on behalf of Mr. Smith. I'd ask the court to please recall the bench warrant. I can come back over. I'm just in the car. I can run back over there.
No, you don't have to do that. Court will set aside the outstanding cases, reinstate the bond. People have indicated they're not ready to proceed this matter.
Yeah, I'd move for a dismissal.
So, or the court will dismiss this matter without prejudice.
Thank you. Mr. Smith.
Yeah.
Can come outside and I'll try to meet you at the corner of Gratiot and Randolph.
Okay.
Thank you.
Thank you.
Have a great day, Judge, you and your staff. I need to come back and get paperwork, or Miss Arnita, would you mind mailing it to me, emailing it to me, please?
Okay.
We'll send it to you.
Thank you. Have a great day.
Thank you, you too. We're gonna do a break to 11 o'clock. This was a surprise, huh? Hi, girls.
Unless you still want.
No. Oh, meet up with card, no. No, you can give me a card, but you supposed to meet up with. Get one card.
Oh, okay, yeah, then we don't have to. So.
Get 1:11. 1:11.
Yeah.
The foster is actually the Elizabeth. I think she has but you just can't go back to that. After the last one, the minutes come to coming, but then I use some of the stuff that we like.
Appreciate it.
Today, to get a line out, you know how we used to do 9, you gotta do 7. They just sent it, After today.
After today?
Yeah.
Okay, hey, Lo, after today, you know, you have to call 9 to get out. After the day, you have to change to 7. 7 is the number to get you out. Okay. Thank you. It ain't as cold today, but it's still cold.
Hey, how you doing? Chambers in the house. Life can be early like that. Always good. Do you have any parties here on Foster?
Yeah, he probably down, I'm calling it up now. He probably down there talking to her, Your Honor.
Prosecutor has witnesses.
Yes.
Probably way. So they talk.
Hey, it is a send up, make some calls. Thank you.
Mr. Washington.
Hi, how you doing?
Good.
Yeah, here on, I'm doing fine. I'm here on Kamisha Foster. Right.
What's your name, Millie? What's your date of birth?
You need to prosecute.
Yes.
Oh, there you go. Hi, Ms. Moore.
Hi, Judge King, how are
Thank
you?
you here.
I am here on Ms. Foster's case.
Calling case 2358882, people of the state of Michigan versus Kamisha Danielle Foster. And this is charged with count 1, assault of a prison employee. Count 2, criminal sexual conduct, 4th degree force or coercion. Thanks for the right.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good morning, I'm Earl Washington, Neighborhood Defender Service, P31383, on behalf of, Kamisha Foster.
Tell me your name for the record. Date, time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor, the people are prepared to proceed. I anticipate calling one witness, and I do ask for each will sequestration order, with the exception for my officer in charge, that's the investigator, Keenan Ali. Is that correct? And that is spelled Kennoli.
The objection to the officer in charge of Mr. Washington?
No, Your Honor.
I'm sorry, Judge, I think I spelled that incorrectly. It's Keenon, last name Ali. I'm so sorry.
Ladies and gentlemen out there in YouTube land, if you are a witness or potential witness in order to log off at this time, there are no other witnesses in the courtroom. Call your witness.
Thank you, Judge. And this time people call Deputy Jasmine Chase, that's spelled JAZMINN, last name CHASE.
Good morning, ma'am. Please step forward, give your name and the spelling of your name to the young lady seated there. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Thank you. Please have a seat in the witness box right next to me. Voice up nice and loud and speak to the microphone. To your left. Thank you. Put the microphone to your left. To your mouth. Maybe get me ready.
Thank you, Judge. Hi, good morning. Please restate your name for the record.
Jasmine Chase.
Ms. Chase, are you currently employed?
Yes,
Where are you currently employed?
Wayne County Jail, Division 1.
Is that through the Wayne County Sheriff's Office?
Yes, ma'am.
How long have you been employed with the Wayne County Sheriff's Office?
Since May 1st of 2023.
So within the last few months.
Yes,
Now, specifically in your capacity with the Wayne County Sheriff's Office, are you employed only in the Wayne County Jail?
yes,
Have you worked for the Wayne County Sheriff's Office in any other building?
no, ma'am.
Now, specifically in the Wayne County Jail, is there a particular ward or unit that you are assigned to?
No,
I'm going to draw your attention back to August 21st of 2023. Were you working in your capacity at the Wayne County Jail?
yes, ma'am.
Do you have an official title there?
Deputy,
And at Wayne County Jail Division 1, is that located at 570 Clinton Street in the city of Detroit? Is that located in Wayne County?
yes.
And back on August 21st of 2023, do you recall which unit or ward of the Wayne County Jail you were stationed in?
We were on 10 Southeast, the large ward.
What do you mean by the large ward?
There's a small and a large ward, so it's from 1 to 6, that's the small ward, from 7 to 16 is the large ward.
And when you say numbers 1 to 6 and then 7 to 16, is that referring to something specific?
Yes, the cells.
So if you were in the large ward, 7 to 16, that was covering people in the cells 7 to 16. Is that fair to say?
Yes,
Now, approximately how long was your shift that day?
I don't remember if I worked a double, but typically it's 8 hours.
Did something occur at that location in that large ward that would you report today?
Yes,
What was that?
I was conducting a round, and as I was hitting the last button with my round pipe, Commissioner Foster smacked and grabbed my area.
Okay, so I'm gonna actually back you up for a second. You said that while you were conducting a round. Now, when you conducted a round and when you were at work that day, how were you dressed?
In my uniform,
Describe your uniform.
brown cargo pants and polo shirt.
Does that clearly identify that you are a deputy in that work?
Yes, it has patches in my name.
You gestured with your hands to your shoulders. Does it have a patch on
It's on
your
my
arm?
sleeves, on collar, the front, and my name is on the front as well.
Does that patch say anything about, I'm sorry?
Wayne County Sheriff.
And you said that it also has your name.
Yes,
Now, you mentioned that you were conducting a round. What does that mean?
we go in to make sure everyone is safe and everything is secure. We count to make sure there's no one hurt or no one trying to kill themselves.
So, did you walk into the large ward area?
Yes.
Describe for me what that looks like.
There's about 2 or 3 tables to the right when you first walk in. To the left, there's a shower at the end. And there's about I want to say 2 tables, I'm not sure. Metal tables, and then along the wall, there's 16 cells, well, 7 to 16.
If you were to see pictures of that ward, would you recognize them?
Yes,
Showing opposing counsel people's proposed exhibits 1 and 2. Permission to approach, Judge?
Yes.
Deputy Chase, what have I just handed you?
2 pictures of basically the whole ward.
Does that look like the ward that you were just describing?
Yes, this is that. They are all very similar.
And just to confirm, I handed you 2 pieces of paper, is that
Yes,
right?
ma'am.
Are those pieces single-sided?
Yes,
Now, specifically, do both of those appear to be a fair and accurate depiction of what the ward looked like on that day?
yes,
Do they appear to be tampered or altered with in any way?
no,
People move to admit people's proposed exhibits 1 and 2.
Any objection? No objection. Admitted.
Now, turning to exhibit 1, can you describe exactly what you see in that picture?
I see a shower, some tables.
Does that show sort of, a minute ago you said that there's one place that you check near the back. Does that show that area?
Yes.
Can you please hold that picture up, maybe so that the judge can see exactly what you're talking about in terms of the area you need to check?
So I start here. There's like a little metal, we call it a metal. It's on this wall. It's across from 16. And then I come around down, and then there's one here. So I hit the furthest one first, which is this one, and I walk in this further back. And then I come out hit this one because it's closer to the door. And I walk out.
Now, I'm gonna make a record of the changing of the exhibits. So you said, first we were looking at exhibit 1, is that correct?
Yes.
Okay. Now you said that there was something that you hit on the far wall. Describe for me exactly what you're talking about.
There's like a, we have a round pipe. So the round pipe, there's like this little, it's like a little knob. And you put the round pipe on it, it makes a beeping noise. That shows basically shift command that we went in, and we made sure that part of the work was secure.
So essentially what you're saying is that by touching the pipe to that little
Knob.
that sends a signal to shift command that that area is secure. Is that what you're
Yes.
saying? Now, how many of those little knobs are in that particular wall?
There's 2, one at each end.
So are you saying that you go to the farthest one first?
Yes.
And on this particular day, on August 21st, did you go to that farthest knob?
Yes, I always do that first.
So when you did that, did you touch that knob to send the signal that everything was secure?
Yes.
Now, after that, what was the next step that you took?
I walked down towards the second one, which is closest to the door.
Okay, now turning your attention to exhibit 2, does that show does that show the second knob that you're talking
Yes,
about?
ma'am.
Now, what are the cell numbers in and around that second knob?
7, 8, 9.
Now, as you were walking back towards the second knob, was anyone in your line of vision?
The only person that was standing up was Foster.
When you indicated Foster, who is Foster?
She's an inmate.
Would you recognize that person if you saw them today?
Yes.
Do you in fact see them in the courtroom today?
Yes, I do.
Please identify where they are seated, without an article of clothing.
She wearing green, the jumpsuit from the jail.
Can you identify where in the courtroom that person is seated?
I can point. She's sitting right there.
Let the record reflect the witness identify the defendant, Commissioner Foster.
So noted.
Now, you indicated that you saw this person. Where did you see this person?
She was leaning up against the wall between 9 and 10.
So using exhibit 1 and exhibit 2, can you pinpoint where that individual was, where the defendant was?
Yes, I can show. Okay, so there's a cutoff on exhibit 1. So it's kind of hard, but on exhibit 2, you can see the wall where she was leaning against. So I would say yes.
So is it fair to say that the defendant was leaning up against where exhibit 1 and exhibit 2 would meet?
Yes.
Permission to approach, Judge?
Yes.
Did you see any other individual or inmate in your line of path?
No.
Now, you indicated that the defendant was leaning up against the wall. Were they leaning towards, were they facing you or facing away?
They were facing me if I was walking there.
Now, as you're walking, what is the very next thing that happens?
I don't remember if I hit the second knob, but as I was walking to that knob, she smacked and gripped as I was walking past her.
We're gonna break that down a little bit. You said she smacked and gripped. When you say smack, what part of her body touched what part of her body?
Her hand touched my bottom in between my legs.
So just to be clear, that's your bottom and backside?
Yes.
Was it one of her hands or both?
Just one.
And you said it smacked and grabbed.
Mhm.
Were those two different points of contact?
No, it was one.
So when you say grab, what exactly did you do?
Just a grip, like this. Just a grip.
What did she grip?
She smacked and grabbed like As I'm walking, my legs are apart. So my left one is behind me, my right one is in front of me, because I'm walking face and out. So she smacked and just grabbed, like, so she smacked it and just grabbed as I'm walking.
And by it,
My, between my legs, like my butt. So her fingertips were on, in the middle of my legs, and her palm was on my leg, and she just grabbed.
so your testimony today that you smacked and grabbed your butt or your buttocks. Now, when that happened, did her hand stay on you or did it eventually go back?
She believed it.
Did she say anything to you when this occurred?
No, I don't remember her saying anything to me.
Did you say anything to her when this occurred?
I did.
What
I
did you
turned
say?
around and asked her why the fuck would you do it?
Did she provide a response?
No.
Now, at the time that this occurred, did you see anyone around? Immediately after this occurred, what was the very next thing that you did?
I walked out of the room.
And when you walked out of the ward, did you go anywhere after that?
I walked out of the ward and called me and another officer called shaking.
Did you tell the other officer what happened?
She did.
Objection.
Sustained.
So I'm actually going to ask my question again. Did you physically tell the other officer what happened?
No.
But did you and the other officer both alert you?
Yes.
What was that other officer's name?
Jefferson. I think it's like a zombie Jefferson.
For the record, that's Azariah, last name Jeffferson. So when you say that you contacted shift command, what exactly did that look like?
Well, before we contacted shift command, Jefferson told her to lock down.
Now, were you physically present when that occurred?
I can hear her screaming lock down as I was walking off of the ward.
Okay, so I'm gonna back up a second. So you said you walked out the ward, so did you still see the defendant at that time?
No.
When you could not see the defendant, did you hear something being said by
Yes.
Officer Jefferson?
Yes.
And what was Officer Jefferson saying?
Lock down.
Is that a command?
Yes.
Did you hear anything in response to the words lockdown?
I heard her say that it was working.
When you say her, who are you talking about?
Commissioner Posty.
Now, when you say you heard that, did you physically see the defendant say those words?
I heard her.
You heard. Now, prior to this interaction on August 21st, have you had other contact with the defendant?
Yes, I speak to her, like I speak to everybody else.
Approximately how long had you known or known of the defendant?
Since I've been working with one company.
So since May of 2023, have you had contact with the defendant?
We started in the jail on June 12th, 2023.
So from June 12th of 2023 through August 21st of 2023, did you have regular contact with the defendant?
I would say I moved around, but yes.
And through that contact, you indicated that you had talked with the defendant.
Yes.
Had the defendant spoken back to you?
Yes.
So did you know what the defendant's voice sounded like?
Yes.
So when you heard someone say it was worth it, did you recognize that voice?
Yes.
And whose voice was that?
Commissioner Posty.
Now, after you heard that, did you hear any other statements from the defendant on that day?
No.
When you ultimately told shift command, what did that process look like?
We had to write a report. And then Officer Ali came in and spoke with me.
1 second, Judge. No further questions, Judge.
Cross-examine.
All right, good morning, officer. Officer, on that day in question, were there any officers in that immediate area besides you?
No, just me.
How many other inmates were there?
I'm not positive, but at least 12.
Now, is this something that you just felt, or did you see it and feel it at the same time?
Singing.
Okay. And where was Ms. Foster in relation to you? Was she behind you, or on the side of you, or in front of you? Where was she in relation to you?
As I walked past, she was behind me. When I walked past her, she was on the side. So if I stopped, she would have been on the left side. As I walked past and she touched me, she was leaning up against the wall behind me. If that makes sense.
You said immediately after you felt that, you said something to the effect, why the fuck would you do that?
Yeah.
Something like that. Was there any response from her?
No, just the other inmates.
And how many other inmates were there?
I want to say at least 12. I'm not sure exactly.
Now, the other inmates, were they all pretty much close together, or were they
Some
spread
sitting
out?
down. There were 2 sitting on the tabletop, and the rest were sitting down. I'm not sure if someone on the phone or standing up by the, I want to say it's called a building, but I'm not sure exactly the duty station.
Okay, do you remember how many were standing? Now, you heard the word, it was worth it, or something like that. Is that a yes?
Yes.
And, this is something that you heard, is that correct? You didn't see it, you just heard. Okay. And you're certain that it was, Ms. Foster's voice that you heard? Now, after you heard that, did you say anything else to Ms. Foster?
No.
Did you have any other contact with Ms. Foster?
No.
One moment. All right, I don't have any further questions.
Can you redirect?
No, you're right, Judge.
Thank you. You may step down.
There's no additional witnesses. You can just give my witness a moment to exit. Then I'll.
You witnesses go to the chamber? No, we have a witness.
Yes, Judge. You can look to bind the defendant over on both counts. The court heard testimony today from the witness who stated that she was working in her capacity at the Wayne County Jail, and that inmates at the Wayne County Jail, who's the defendant, did assault her while she was conducting her regular rounds. She indicated that the defendant smacked and then grabbed her butt or buttocks while she was walking, and that she later heard a statement made by the defendant and said, for probable cause standard today, Judge, the people have met their burden. I reserve further argument for all.
Mr. Washington.
Judge, we object no argument.
What after hearing testimony of Ms. Chase is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint form. Court finds those charges were committed in the city of Detroit. The court finds probable cause for the listed. It will be filed over to the county third circuit court. Criminal division for proceedings. Per arraignment on the information date and time will be October 4th, 2023 at 9:00 a.m.
Judge, this way now.
Just have to see somebody to get you in shape.
Ready, Mr. Chambers?
Ready, Judge.
Is your client in or out?
They should be bringing them up, Your Honor.
Okay. All right.
Yes, sir.
Yes, sir. Gave me a bonus today.
Huh?
I said, you gave me a bonus today.
I did.
Yeah.
Oh, yeah.
Oh, yeah.
Absolutely. This is it, right?
Yes, sir. So welcome to your lawyer.
Calling case 2358495, for the state of Michigan versus Dwayne Johnson. Defendant charged in count 1 assault with intent to murder, count 2 assault with intent to do great bodily harm, living murder or by strangulation, count 3 assault with dangerous weapon. Case for the
Good morning, General Garden Chambers, P63956, on behalf of Dwayne Johnson.
Tell me your name, sir. There's a date, time set for preliminary examination. Are you ready to proceed?
Yes, Judge, I have one witness.
One witness.
Judge, I would be asking for an adjournment, Judge, and I did discuss this with the prosecutor, Sheriff. Why? We had long at the probable cause conference, maybe even the second before the requested digital discovery in this matter. I've been in communication with Ms. Drain over this time with regards to the digital discovery. There was digital discovery that was tendered to me last night, approximately 9:30-ish. I was able to download and briefly overlook, but not fully review all of this discovery. There's also still, to my understanding, outstanding body camera from the officer that arrived at the scene. Now, it is my understanding with my discussion with Ms. Drain that she has been attempting to get these items to her so she can give them over to me. I do believe they were just given to her late yesterday, last night, and I do believe that she immediately forwarded what she had over to him. Judge, quite frankly, I mean, I haven't put anything in writing on this, Judge, and been in communication with her. The reason I didn't put anything in writing, quite frankly, is because I've been consumed with kidnapping case, Judge, that has a voluminous amount of discovery, of which there was a preliminary examination yesterday, and then a trial scheduled today, which I'm prepared for. So I would ask for an adjournment to be able to get the body cam, Judge, and fully prepare for this examination. Ms. Drain understands my asking. I will acknowledge that I have been told that the complaint is here.
Thank you, Judge. Yes, the complaint is here, and we are prepared to go forward. So as soon as we set the PCC, as soon as we set the exam date after the PCC, I sent an email to the listed officer in charge of this case, that would be Officer Jermaine Owens from the Major Crimes Unit, requesting the discovery. I had not received the discovery. I had been in discussions with defense counsel, and when I
as I didn't receive discovery, nothing was uploaded to evidence.com, I called another officer and I said, how can I get in touch with this officer because he hasn't responded to my email that I need for discovery? And I was informed at that time that Officer Jermaine Owens has not been with the Detroit Police Department for at least a year now. So he's not even there. So I didn't know, and there was no other officer in charge that was assigned to this case. So I'm not sure what happened there. I said, who else can I call? I did get a number for someone else. I emailed that officer. He did send me what they had, which was pictures and 1 20-minute target. So as soon as he sent that, I immediately sent that to him. He indicated to me he didn't know if there would be any digital, because there was nothing that he had. So we have Officer Fitzpatrick, who is now assigned to this case. He has informed me they don't have any other digital discovery that was from Wayne State. He would have to look to find out if there is any body wear camera available at all on this case. But we don't have it. Right? If it is available at all. I wouldn't be using anything from that. All the charges are based on what happened before anybody got
there. I was just saying that according to the reports that there is full uniform, fully marked vehicle, body worn camera, and on and operational is what this notes. So
Granted, that this is over a year ago, we know that that is still going to be available.
Statutorily, it should be. They are required by statute and law to save such video, body worn camera specifically, not scout camera, but body camera.
I'm not inclined to grant an adjournment on a present supposition that this alleged body cam evidence exists. I'm hearing that they don't have it. I'm also hearing that there's been a change in circumstances with the officer in charge of the case. Somebody dropped the ball somewhere. And unfortunately, we have an officer in charge now who has picked the ball up and has forwarded what he has to Mr. Drain, and Mr. Drain has forwarded the same to you. And although I appreciate how busy you are, counsel, that's because we do. How busy you are. If you need additional time today, in the next hour to look at this video, I'll give you that. But I'm not inclined to adjourn their examination.
Let's go with it.
Are you?
And Your Honor, I also put in front of counsel on notice that based on the written testimony, there may be an additional charge added.
Anything put on notice, counsel?
I just sent a people come here from Elizabeth West.
Please give your name and spelling to the young lady seated there. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat to the witness box right next to you. Keep your voice up nice and loud and speak to that microphone with you to your right. You may begin when you're ready.
Thank you. Please state your name once again for the record.
Elizabeth Webb.
All right. Ms. Webb, I want to bring your attention back to the date of July 3rd, of last year, 2022. Do you remember that date?
Yes.
All right, what were you doing on that date?
Me and my ex-boyfriend had went out to his cousin's birthday party. It was kind of like a block party. We were drinking and, just mingling. I guess a rumor had got around that I was speaking to one of his,
Some sort of speculation or hearsay.
I'm gonna ask you another question. So you indicated that yourself and your ex-boyfriend were at a party.
yes,
And who's your ex-boyfriend?
Dwayne Johnson.
All right, and do you see Dwayne Johnson in the courtroom here today?
Yes.
Could you indicate where he's sitting and what he's wearing today?
He's sitting to the right of you and he's wearing a green jumpsuit.
Thank you. Your Honor, please, this record reflect because this has identified the defendant, Dwayne Johnson. All right, at some point, did you and Mr. Johnson leave the party?
Yes,
Okay, and where did you go?
we went back to my house.
Okay, and where's your house located?
1277 Selden.
Is that in the city of Detroit, the county of Wayne?
Yes.
Okay, and when the two of you came back to your house, was there anyone that came with you?
No.
And when you arrived back to your house, was there anyone at your house?
No.
What happened, if anything, on the ride to your house?
We just had words in the car. That's about it. We kind of argued the whole way back. When we pulled into the parking lot, we sat there, had more words, and then we went into the house.
Okay, this is a house or an apartment?
It's a townhouse.
Townhouse, okay. All right, so you get into the townhouse. What happens after that?
I began to just take my clothes off. I'm like, I just want to lay down, go to bed. Got into my room. Argument somehow started back up. And at that point, I was fed up. I'm like, I don't want to do this no more. And he snapped.
Okay, and when you say he snapped, what do you mean by that?
He just blacked out. He started to choke me. Grabbed me, choked me, picked me up in the air. He let me go. And then he started walking back and forth, just talking crazy talk. And then he grabbed me again and choked me again to the point where I was almost unconscious. I became scared. I ran into the bathroom, locked the door with my phone, trying to call 911. And he came and kicked the door in.
Let me stop you right there for just a second. Okay, so you said that he choked you.
Yes.
And you said to the point where you almost lost consciousness?
Yes.
What did he choke you with?
His two hands.
Where were his two hands?
Around my neck.
Do you know how long his hands were around your neck for?
At least 8 seconds.
So you said you almost lost consciousness. Was your breathing restricted? Is that what you said?
Yes.
So you said you then ran into the bathroom and locked the door?
After the second time, yes. I locked the door.
Okay. And you tried to call 911?
Yes.
Did you call them?
I tried to. I dialed 911 and that's when he kicked the door.
Okay. All right. So, Mr. Johnson is then outside the door, he kicks the door in.
Yes.
Does he damage the door when he does that?
Yes.
How does he damage the door?
Where the latch is, it just, because it's wood, so it chipped off.
Okay.
It was to the point where you can't even lock it anymore.
So what happens when he kicks the door?
He grabs the rubbing alcohol that was sitting on by the sink and sprayed it on me.
Okay, so there was rubbing alcohol by the sink.
Yes.
And was this in like a bottle, a little container? Can you describe what that was?
It was in a bottle.
Okay, whose was that?
It was mine.
Okay. And you said he sprayed them. What do you mean exactly sprayed them?
Because it's like in a plastic bottle, and he squeezed it. He swirls it and it sprayed out.
Okay.
And he held it up so he could get me good.
Okay, so where are you standing? Where is he standing when this happens?
He's standing to my left and I'm kind of leaning, trying to block it because he's trying to get my face, trying to block it.
Okay.
And that's why my arm is the main burn is on my arm.
Okay. Could you clearly see what he was doing?
Yes.
Okay. So he sprays you with the bottle of alcohol.
Yes.
Where does that alcohol, this liquid, correct?
Mhm.
Where does that land on your body?
Most of my left arm and chest area where like my shoulder meets my arm. A little bit on my face, chin, middle of my chest, and a little bit on my right arm, my right shoulder.
Okay. Now, you said earlier that when you came home, you took your clothes off, you went to bed, is that correct?
Well, I started to take my clothes off.
You started to, okay. So what did you have on, if anything, at that time?
I just had on my dress and a bra.
Okay. All right, so after he then sprayed you with the rubbing alcohol, what happened after that?
He took the lighter out of his pocket and lit me on fire.
Okay, he took a lighter out of his pocket?
Yes.
Did you know he had a lighter in his pocket?
No.
Okay. How quickly did all of this happen?
Felt like seconds, like maybe 3 minutes.
Okay. What did he do with the lighter? Did he hold it by the bottle? Did he hold it by you?
He held it by me.
Okay. And what happened to you when he did that?
I ignited into flames. I began to panic. And my first mind was to jump in the shower. I got in the shower and I'm still panicking. I can't even get to the knobs to turn the water on. And at that point, I guess he snapped out of it and he helped me turn the water on to put me out.
Okay, Mr. Johnson helped you turn the water on?
Yes.
Okay. And, what are you feeling? Are you feeling anything physically right now?
Yes, I'm still feeling like I'm on fire.
Okay.
Even though I'm not.
Okay. So does the water come on?
Yes.
Okay, and what happens after that?
Like my skin begins to melt. I'm just looking down, still in the shower, I'm looking down at myself and I'm just in shock, you know.
Can you see the areas where it was ignited?
It was burnt skin, so some of it looked like blisters.
Okay.
Some of it was coming off, I can see the redness. Most of it was still kind of blistered, burnt skin.
You said some of your skin was coming off?
Yes.
Okay. How long were you in the shower for, do you remember?
Only like 2 minutes.
What happened after that?
I got out the shower, that's when he began to panic, saying things like, he don't know, he can't believe he did that, he's gonna go to jail. That's when he grabbed a knife and tried to say he didn't want to be here anymore. And at first I said, you know, I need to go to the hospital, I need medical attention. And then he kind of looked at me and I'm like, you know what? You know, he's like, oh, you're gonna tell on me and all that. I'm like, I don't know, I became scared. So I'm like, I don't want to try to leave. And he tried to stop me and do something to me.
So what did he do with the knife then?
He eventually put it down. He was like running up and down the stairs with it. I don't know where he put the knife. But we eventually ended back up in the room and he kind of calmed down. I told him like, you know, I forgive you. It's okay. Everything's gonna be all right because I fear for my life.
That's what you said those things?
Yes.
Okay. What
I
happened?
was afraid if I left, you know, he would intercept it and try to harm me. So, I saw that he was winding down, he laid in the bed and he finally went to sleep. So I crawled out of the bed and I realized that my phone and keys was missing. So I just threw on some clothes and I started walking. I walked to the hospital.
Walked to the hospital?
Yes.
How far away was the hospital?
About 30 minutes.
Which hospital did you go to?
Harbor Hospital.
Were you treated at the hospital?
Yes.
What did they use you to treat you?
I had skin graft surgery and I had one session of laser skin surgery and I have a few more sessions to go.
Can I approach the witness? Ms. Webb, I just handed you two documents. Do you recognize those documents?
Yes.
What are those documents?
Pictures of me.
And do you know when those pictures were taken?
July 3rd.
July 3rd of 2022?
Yeah.
Okay. What do the pictures depict?
Pictures of my burns.
Okay. And was this right after it happened?
Yeah.
Okay. And are these two pictures an accurate representation of what you looked like after you went to the hospital?
Yes.
Thank you. Right, at this time, based on the witness's testimony, I would move to admit.
No judge, for example.
Admit it.
Right, at this time, I would move. All right, this time I have no further questions.
Cross-examine. Yeah, well, I'll start with a brief. Oh. So we had an opportunity to give a written statement to the police with regard to this matter, right?
Yes, and I did.
And did you review your written statement before coming to court today?
Not the written, I listened to the videotape.
Okay, so there was a video recording, or there was a recording of the statement that you gave as well, fair to say?
Yes.
Right, so you told the police basically what happened when they first arrived, is that accurate?
Yes.
What happened? When you gave your written statement, was that in your townhouse or was that at the police department?
It was at my townhouse.
Okay. Can I approach you? Yes, Richard, where I'm showing you will be page 3 or 6 of your written statement. Is that your signature at the bottom of the page?
Yes.
And is this your written statement that you gave?
Yes.
And right here, I have a little portion bracketed. Could you just read that to yourself? No, just and you were asked, where did Mr. Johnson produce the lighter from? And your answer was he already had it in his hand, right?
Yes.
And just to be clear, obviously and unfortunately, your clothing, your skin caught fire, correct?
Yes.
And then you pretty much immediately tried to cut the water on, put it out, fair to say?
Yes.
And you were having trouble doing that, correct?
Yes.
And then it was basically immediately Mr. Johnson and cut the water on and help put the fire out, fair to say?
Yes.
And after that point, he didn't physically assault you at any time, correct?
Correct.
And you testified to a knife. With regards to that knife, he was holding that knife talking about self-harm. Is that fair to say?
Correct.
Right, he was threatening to hurt himself with that, right?
Correct.
And then sometime soon thereafter that, kind of pleading with you not to go, and then he eventually goes to sleep, fair to say?
Yes.
And then that's when you go to the hospital and get your injuries taken care of, right?
Correct.
This rubbing alcohol there was still rubbing alcohol left in the bottle after he squirted some out. Right? He squirted some, he didn't squirt the whole bottle. If you recall.
It wasn't much.
It wasn't much. Fair enough. Thank you. That's right.
Do you redirect?
Nothing further, Your Honor.
This night that you referred to, that you said he had, you ever threatened you with the knife?
No.
Any questions based on my question?
No.
No, Judge.
Thank you. You may step.
Thank you. Your Honor, I have no further witnesses at this time.
Any witnesses from the defendant?
Not now.
People.
Thank you, Your Honor. At this point, I would move to bind over as charged with an additional count of assault by strangulation. I'm moving to add that because the witness clearly testified that in addition to being burned, the defendant also put his hands around her neck 2 times. One time she indicated that he didn't, and she almost lost consciousness. So I'm moving to add that.
Judge, just to that kind, I'll object to Judge argument. She didn't lose consciousness. But with regards to what I believe more concerned is the able to try to say something. Judge, I just simply argue this is GBH. It's a very unfortunate situation. I understand that. Fires never good. But I do believe that his actions show his intent was and most commit great bodily harm, Judge. He wasn't trying to kill her. He would not have immediately thereafter put the fire out if he was trying to kill her. He would have had the opportunity if he was trying to kill her to continue to assault her. He does not do that. He eventually goes to sleep. Judge, it's just not able. It's GBH. It's an unfortunate GBH. I get that. No one wants to be burned, Judge, but it's not able. Sure.
I am moving to bind over at this point on the assault with intent to murder. Setting someone on fire. Your intent is to kill them. You know what is going to happen when you set someone on fire. Thank goodness they were in the bathroom and she was able to get water on her and wash it off. If she hadn't been able to do that, she likely could have died from that. Setting someone on fire is much different than doing other things that are assaultive with the intent to just do great bodily harm. It's more than great bodily harm to set a person on fire. People die from being burned to death. And I believe that that's what he meant, and I believe that that's what she testified to.
So, additionally, I've always found that criminal sexual conduct and assault and intent to murder cases are always the most difficult cases to prove. Because the argument is always, particularly in assault and intent to murder cases, if he really intended to kill her, why didn't he just finish the job? But I think there really needs to be some refocusing here that at the moment in time that the act was committed, what was his intent? Not what he did afterwards to try to remedy the situation, but at the time that he doused her with alcohol, took a lighter, and then set her on fire. What was his intent? Was there an intent to do great bodily harm? Was there an intent to murder? I submit to you that I believe that would be a question, in fact, to be determined by a trier of fact. A rational trier of fact could find that by dousing someone with rubbing alcohol, setting them on fire, your intent could possibly be to kill that person, or it could be to inflict great bodily harm. And that's say what he did afterwards. Whatever happened to make him realize, oh, I really messed up here. When you try to remedy the situation. But at the time that he set her on fire, what his intent was really not looking. That being the case, The court is satisfied that people have met their burden of probable cause as it relates to count one, assault with intent to murder, as well as count two, assault with intent to rape, bodily harm, less than murder by strangulation. And count three, assault with a dangerous weapon, as well as the added charge of assault with intent to rape, bodily harm, less than murder by strangulation for the alleged strangulation, which she said that she almost lost consciousness as a result of being choked by the defendant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this has been committed. And it will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. Is arraigned on the information date and time will be October 4th, 2023 at 9:00 a.m.
There's man address on it. So this incident took place a little over a year ago. It was in July of 2022. The case that wasn't charged until August of this year. We don't know the reason of the delay. Perhaps the prosecutor's office does. I surely don't. But with that said, Judge, my client in the interim had moved up to Las Vegas. He's living in Las Vegas and working in Las Vegas. He's not hiding out in Las Vegas, Judge. He has a lease in his name. He had a job at Amazon working full-time, has been there for a number of months. Born and raised in Detroit, Judge, understanding that if he's not allowed to go back to Vegas, he has to remain in the state, he would live here with his mother, Judge. Upon his arrest, and they came to his house, Judge, is where they arrested him, which is where he was. I'm sure they're able to find him because that's where his legal, address there with the lease. He would be staying with his mother, Judge. Upon his arrest and going to jail in Vegas, he signs off on the extradition. He contacts and communicates with his mother. His mother then communicates with me and sets the wheels in motion to retain me. I was retained as he was being transported here, Judge. I understand fire. That kind of bothers us. They really like to hear the word. I get that. There will be no communication and no contact with the complainant, Judge. There's no violent history here with this man. There's no felonious history here with this man. I can tell you that if he is tethered to a location, he'd be tethered to his mother's home. And Judge, I've known his mother since the late 80s. She's a CAS graduate, class of 91. He'll be fine there. She's not having it. He's going to be more than respectful at that location. I just don't see any harm to or danger to society. He's been in communication with me. Obviously, he's been in jail since this time, so I've been able to get over there on more than one occasion to speak with him. I've been in constant communication with his mother as well. He's not like this. He's going to face these charges. And of course, he's going to do is run from for the rest of his life. He's not going to do that. So I would ask for a lower judge for something that he could reasonably make. He is employed. He simply does not have much money, if any, in the bank. He's indigent for the most part. I retained by his mother. I would ask for 50,000 and 10% judge with the restrictions that this court received. Mr. Chairman?
Your Honor, this is a very, very serious case, very serious allegation. I would ask that there be no change at this time. I would ask for a pretrial services report for more information.
So some of the positive things that the defendant has in his favor, one of which is that doesn't, so far as I can tell, have a prior criminal history. At some point in time, allegedly after this incident, the defendant came to his senses and tried to help the complaining witness. Did he contest extradition?
No, you started off on that, Judge, immediately.
Didn't contest extradition when he was brought back. Now the negatives, although the court doesn't look to punish the defendant by way of bond, this is a very egregious case that sets him on fire. One, two, he came in with less charges and leaving out, but picked up actually another felony, another 10-year felony. And then third, outside ties to another state. So I'm left to ponder, if I was to reduce his bond, if something happens, and that's not to say it's something good, but if something happens, everybody's gonna be looking at me. Judge King reduced his bond on a person who set someone on fire and was charged with 2 counts of assault, intent to do great bodily harm, assault with intent to murder, and the dangerous assault with a dangerous weapon. I would look pretty crazy for doing such a thing. Even if I was to put him on house arrest, no contact with the complaining witness. Situations like this, the court likes to err on the side of caution. I'll refer to pretrial services for bond recommendation. Take that up with the right stage. Finally, to well, guess what, folks? That concludes the docket for today. Hope to see you tomorrow. Same bat time, same bat station. Have a good day.
Crazy, what?